Good afternoon, everyone. My name is Teilen Celentano, and welcome to today's iteration of the live employment law Q&A. Like I said, my name is Teilen Celentano. I'm an employment lawyer and associate with Samfiru, Tumarkin, LLP. I'm based out of the Toronto office in Ontario. If you guys have any questions, feel free to post them right now, whether it's through Facebook, LinkedIn, Twitter, X, YouTube, and I'll answer them live. If you have any more questions, feel free to go to employmentlawyer.ca or email us at help@employmentlawyer.ca or call 1-855-821-5900. I'll start off today by speaking briefly about the Metroland Media Group layoffs. So as you may know, Metroland Media Group has made the decision to lay off 605 employees and end the print edition of its community newspapers. In doing so, it seeks creditor protection under the Bankruptcy and Insolvency Act. So what does that mean for their employees? What does that mean for those 605 people who now find themselves out of work? Well, when a company seeks creditor protection under the Bankruptcy and Insolvency Act, it first needs to be approved. Once it is approved, it's likely that Metroland will not have to imply those 605 employees their full severance. A full severance can be as much as 24 months. It depends on a number of factors, including your age, your years of service, your tenure with the company, etc. So if their bankruptcy is approved, then people seeking severance will be considered what's called an unsecured creditor. And in a bankruptcy, unsecured creditors go to essentially the back of the line, and secured creditors get paid out first. Secured creditors are typically things like banks, and when assets are liquidated, they're the ones who are paid first. So unfortunately, if the bankruptcy is approved, the non-unionized worker will receive little to no severance. Conversely, if the bankruptcy is not approved, then the former employees will have the ability to pursue a full severance package. So there's a lot of play, and it's something to keep an eye on. It doesn't necessarily mean it's not definitive yet. There's still hope for those employees. So Sally on YouTube says she was recently let go from her employer and was given 7 days to sign and return their offer. She says it's not enough time to speak with a lawyer. Is there anything she can do about the deadline? So generally speaking, there's nothing we can do to extend the deadline definitively, but generally speaking, those dates are arbitrary. If you ask for extra time to speak with a lawyer, companies will oftentimes accommodate it. And then oftentimes, in my experience, if you after you speak to a lawyer, even if it's a day or two after the deadline, companies will oftentimes accommodate it. Doesn't always happen. There's always room for the companies to take a really hard line. But generally speaking, if you ask a company for more time, they will accommodate it. And even if you try to accept it after the 7-day deadline, you're still okay they'll still pay out the package. Christina Trevelyan says she's been with her employer for 5 years, but has never signed a contract. Should I be concerned about this and ask for one? So no, you shouldn't ask for one, nor should you be concerned about it. When you do not sign a contract and you're not given one, it means that the terms of your employment are subject to the common law. Generally speaking, the common law is a lot more favorable to employees than what a contract can provide. So don't freak out. Don't worry about it. If you don't have a contract right now, that's totally okay. There's thousands of employees in Ontario who don't have an employment contract, and we help them out all the time. So just continue going as a status quo. If there's any significant change to your employment, meaning they change where you're working and you're going to have to drive much further, if they change your hours, if they try to reduce your pay, if they try to lay you off for the first time is a big one. Give us a call. Either give us a call at 1-855-821-5900 or go to employmentlawyer.ca, and somebody from our firm will be able to speak with you and get you in contact with a lawyer who will be able to advise you on your rights at that point. But for right now, no, you don't have to worry about it, and you shouldn't ask your employer for one. Okay. Danica Shimbashi asks, can my employer force me to retire once I hit a certain age? This is a pretty common question we get from people who reach out to us. The short answer is no. An employer cannot force you to retire once you reach a certain age. The Ontario Human Rights Code applies to all provincially, federally regulated employees, and the Canada Labour Code applies to all federally regulated employees. And both legislations prevent discrimination on the basis of age. So, if an employer is trying to pressure you to retire, is trying to push you out once you've hit a certain age, then that is contrary to both the Human Rights Code and the Human Rights Act, the Canada Human Rights Act. So if that's happening, absolutely contact us, again, whether through employmentlawyer.ca or at 1-855-821-5900. One of our lawyers will be able to help you. And in that case, not only would the company be liable for human rights damages, we could also potentially pursue severance damages as well. Again, a severance package can be as much as 24 months, depending on a number of factors. And one of our lawyers will be able to help you out. Rudy on Facebook asks, my employer has not been paying us on time. I've been charged late fees and NSF fees for my bank as a result. Are they required to compensate me for this at all? In short, that is something that a company is liable to compensate you for. It's their actions that are causing you to accrue those damages, those lost money. That's typically something that can be handled through the Ministry of Labor. But give us a call or reach out to us at employmentlawyer.ca, and one of our lawyers or paralegals will be able to help you out. Reggie asks, I've been working as a contractor for a local production facility for the last few years. My contract states that because I am a contractor, I am in a contractor role, I have no severance entitlements. Is that true? So the law surrounding employee versus independent contractor is very favorable towards employees, but is somewhat murky. So generally speaking, if your contract says you are an independent contractor, but you work exclusively for one company, they dictate where and when you work, and they exercise a significant amount of control over your work, then despite what your contract says, you are actually an employee. And in that case, you would be entitled to full severance. And in the event that you were actually a contractor, but you were wholly financially dependent, meaning 80 to 90% of your annual income comes from this one company, then despite your status as a contractor, you'd be considered what's called a dependent contractor and thus still entitled to severance. So just because your contract says one thing, it isn't determinative of the actual employment relationship. So in the event that you are let go or there is a substantial change to the terms of your employment, absolutely reach out to us. Again, that's at employmentlawyer.ca, and we'll be able to help you out. Just because your contract says you're a contractor and you're not entitled to severance doesn't mean that's actually true. Our courts are aware that companies will write these contracts in the most favorable way for them, even though it doesn't necessarily provide everything it should under the law. Raj Sharma asks, what's the average time it takes to negotiate a severance and pay off employee after termination without cause? Is there any legal guideline to pay off employee by X weeks or months? In short, it depends. It's the typical lawyer answer, but it really does depend. And how long it takes to pay depends on a number of factors. Even though an employee is getting let go without cause, there are always different aspects at play, whether it's the financial stability of the company, their appetite for settlement, and especially with small companies, just the overall relationship, whether there was a significant amount of animosity between the parties or not. Generally speaking, we can send out a demand letter within a few weeks and hopefully reach some settlement then. If not, anywhere from 6 to 9 months is a good timeline. But unfortunately, if the company takes a very hard line and decides to push it all the way to court, it could take longer. There's a significant backlog with our courts. That said, myself and all the other lawyers with my firm, we do our best to push things and reach a fair and equitable resolution and settlement as quickly as we can. But there is no legal guideline to say that someone has to have to pay severance within X number of weeks or months. Only the minimum amount on the Employment Standards Act need to be paid within a prescribed time period. That's 2 weeks or on the next regularly scheduled pay period, whichever comes first. But otherwise, no, there's no strict guideline. There's a question from Milk on YouTube. He asks, can an employer take action against you for your activity on social media if you comment on or support political parties posts, for example? Generally speaking, no, they can't. They can't terminate you for cause or suspend you for anything like that. With that being said, though, employers in Ontario do always retain the right to terminate an employee without cause. So if you were to post something that were to post or interact with a post on social media that they didn't like, they could choose to let you go of their own volition. In that case, they would need to pay you a fair severance package. And again, a fair severance package is wholly dependent on the circumstances of your employment, but they are allowed to terminate you for cause. Unfortunately, in Ontario, political speech is not a protected right under the Human Rights Code, the Employment Standards Act, or any other related act. So they would be permitted to let you go, if they didn't like something you did on social media, but they would need to just pay you a fair severance package. Denver asks, I work for a U.S. company. My contract says I'm at will. Can you explain how that impacts me here in Toronto? So the doctrine of at-will employment is a concept that exists in the United States, but doesn't exist here. So generally speaking, it's that an employee at will in the U.S. Can be terminated without any cause and without any notice. Fortunately for employees in Ontario, that doesn't exist here. So if your contract says, like Denver, that you're an at-will employee, then a court would decide that term of your contract is illegal and would be struck from your contract. You would then be entitled to severance, a full severance package, which again can be as much as 24 months. So don't raise this issue with your company. Just sit on it, and if in the event that you are let go, absolutely reach out to us at employmentlawyer.ca, and one of our lawyers will be able to help you. That term at will oftentimes appears in contracts when someone is working for an American company and they're one of the few, if not only, Canadian employee that they have, and they just haven't retained a Canadian lawyer to help them out. Ronald asks, my employer wants me to complete some company training, but has asked me to do it on my own time after work hours. Are they allowed to do this, or should they provide me with time during the workday to complete this? So under the Employment Standards Act, all training time is work time. So they do have to compensate you for your time, for the time you spend completing the training. So they ask you to do it after hours, submit your hours afterwards, or otherwise complete the training during the workday while you're on the clock. Company is not allowed to ask you to spend your own time when they're not paying you in service of the company. So no, short answer is no, that they do not have the right, and that they should be paying you for your time spent after work, or providing you with time during the day to complete the training. Question from JB on Reddit. He asks, can an employer prohibit you from talking about your salary with coworkers? No, they can't. It's generally understood that speaking about your salary is a faux pas in workplaces, but there's no law that prevents you from doing so. And in fact, doing so can oftentimes, speaking about your salary with your colleagues, can oftentimes expose other things such as potentially not equal pay for equal work not being respected or other things. So no, there's nothing that an employer can do specifically to prohibit it. It can be frowned upon, it can be looked down upon, but there's nothing that says, point blank, they're allowed to prevent it. With that being said, again, as I mentioned before, if you are doing it and an employer doesn't like it, they are permitted to terminate you, but in that case, they would have to pay you a fair severance package. Raj asks, if an employer said it will be a hybrid model while joining, verbally and not on offer letter, and changes it to work in office 5 days a week, can that be considered a constructive dismissal? So it's difficult. It's difficult and will depend largely on what you said or what was said in the contract when you joined. There are various terms and contracts that can be included, one of which can say we reserve the right to determine your place of work. And in a case like that, that would be either working from home, part-time, full-time, or in office full-time. So it's difficult to say without having seen your contract. So in that case, please reach out to one of us, and please reach out to us at employmentlawyer.ca, and one of our lawyers will be able to take a look and advise you. But I think this question really highlights the importance of, whenever you are interviewing or joining a new company, of getting everything in writing. Oftentimes contracts do have a clause, an entire agreement clause, which says something to the effect of, everything that we've agreed on is on paper and there is nothing else. And those clauses are pretty strong in court. So it's really important that when you do choose to join a new company and there is a verbal agreement there's a verbal agreement for something like a hybrid workplace, it's important to get everything in writing. But it could be considered a constructive dismissal, Raj. We would just have to see your contract itself. Mina's asked a question regarding insurance company and CPP disability. Mina, that question is better suited for one of our disability law Q&As. Our next one's going to be held on September 26th at 1 p.m. So as an employment lawyer, I can't answer that question, but one of my colleagues will. So please join in again on September 26th at 1 p.m. for a disability law Q&A, and one of my colleagues will be able to help you out. NT on Reddit asks, my employment contract says I have to give 1 month notice to resign. If I give less than a month, are there any penalties or issues I could face? So in short, yes. If the company can prove that as a result of you giving shorter notice, whether that be 2 weeks, 3 weeks, 1 week, no weeks, if the company can prove that they suffered damages, i.e. they lost money because of your actions, they could potentially sue you for the amount of money they lost. Now, those suits are very rare, but they are possible. So, we always recommend that if a contract says 1 month notice to resign, give that notice. But because there are potential penalties that could ensue. So Sam on YouTube asked, what happens if I give my 2 weeks notice and am terminated on the same day? Am I owed any severance at all? So if you give your company 2 weeks notice and they terminate you on the same day, so I'm assuming it happens during the same meeting. So you walk in and you say, I'm going to leave in 2 weeks. And they say, all right, well, we're going to let you go right now. Then all that you're owed is those 2 weeks of pay. So a company is permitted to waive a notice of resignation period. But what they have to do is they have to pay you. So they have to pay you to stay home. If the company is, if your company, Sam, is not paying you, if they're refusing to give you any money at all, then absolutely give us a call. Again, 1-855-821-5900, and one of our lawyers will be able to help you out. They do have to give you those 2 weeks pay, but they wouldn't be liable to pay you anymore. So on Facebook says, my employer sold the business to a new company who does the same work. Most employees were offered new positions with the new owners, but some were not. Are the employees who were not offered positions entitled to severance? And who is responsible for paying that? So once again, the answer is it depends. So yes, the employees who were not offered new positions are entitled to severance. Who pays it depends on how the transaction took place. So when a company is sold to another, there's two ways it can happen. One is through an asset purchase, meaning that the new company purchased all of the assets from the old owner, and the second is through a share purchase, meaning that the new company purchased all the shares in the old company. So whether it was a share purchase or an asset purchase determines who is responsible for paying the severance. But either way, the employees who were not offered new positions are entitled to severance. How much severance depends on a number of factors. It can be as much as 24 months pay. And there could also be a potential for additional damages depending on how those employees were selected to not be offered new employment. For example, if the new owner decided not to bring back all the older people in the workplace for whatever reason, then it is possible that there could be a discrimination issue as well, and the company could be liable to pay additional damages for that. So if you or any of your colleagues were not offered a new position, Paul, absolutely reach out to us at employmentlawyer.ca, and one of our lawyers will be able to help you out. Reggie, as a follow-up to the previous contractor question, Reggie says he works full-time for a company, 9 to 5, and it sounds like he's not a contractor. Do I say anything to your employer about this? Generally speaking, it's okay to just wait and see what happens. But if you do want to raise this issue with your employer, it's important to reach out to one of our lawyers before you do so. I, of course, haven't seen your contract or know the exact terms, so I can't say definitively whether or not you're a contractor or an employee until that happens. So if it is something you want to raise with your employer, I'd suggest reaching out to us at employmentlawyer.ca and scheduling a call with one of our lawyers who will be able to, definitely tell you either way and be able to guide you on what next steps you should take. KN on YouTube asks, I am being forced to move into a different position at my job and not being paid for the training. I do not want this new position. What can I do about this? So once again, KN, the answer is it depends. So if you are, if the new position is largely similar, for example, you're going from an accounts payable clerk to an accounts receivable clerk or something like that, and the character of the employment, meaning your day-to-day, whether it's a desk job, a job outside, that kind of thing, if that's staying the same, then generally speaking, companies are allowed to move employees around within the company. That said, they do have to pay you for the training. I mentioned this earlier today, but the company does have to pay you for training. If it takes place after hours, they have to pay you your hourly wage, or the training can take place during the workday. Irrespective of whether or not they're changing your position, they do need to pay you for the training. With that being said, if they are willing to pay you for the training and the position is, the character of the employment of this new position is largely similar to your previous one, they would have the right or they would have the ability to put you into this new position. But that can be a complex question, right? And the movement within the workplace is always difficult and can sometimes result in a constructive dismissal. So I would suggest reaching out to one of our lawyers, reaching out to us through employmentlawyer.ca, and the lawyer will be able to take a look at your file, your contract, the circumstances of your employment, really give you a tailored answer to your question here. Raj asks, is there any common law guideline regarding the duration of extending health benefits as a part of a severance package? So there is the Employment Standards Act, which says that it needs to be, your health benefits need to be extended for weeks at a time. And then there's also the common law. So what the common law says is that you need to be made whole for your whole reasonable notice period. So if a full severance package were 24 months, let's say, then the company would need to extend your health benefits for 24 months. And that includes all of your health benefits, not just your prescription and dental coverage, but can also include things like life insurance, disability insurance, and accidental death and dismemberment insurance. All of those need to be extended during the common law notice period. So, if you're ever presented with an offer that doesn't, contact us, and we'll be able to help you out, negotiate a package that does extend it. Our courts have said that a common law notice period is an art and not a science. So there's no real rule of thumb that says exactly how long it should be extended. But yes, those benefits do need to be extended and should be included as part of a severance package, as well as other components of your compensation as well. For example, if you received a subsidy for, if you had a car allowance, a phone allowance, a home internet allowance, things like that also need to be included in a severance package for the duration of the notice period. ML Abroad asks, are people getting severance yet for not taking vax shots in nursing homes in a non-unionized context? So it really depends. It's the issue of vaccination against COVID-19 is still unsettled. So it's a case-by-case basis, and it's difficult. There's some are, some aren't. Okay, so last question for today, and then we'll wrap things up. Black Alley Cat on YouTube asks, I've been told by my company that they are closing in 12 months' time. Is this considered verbal notice? Am I not owed any severance in this case? So notice of termination needs to be in writing. So that's one of the things that is required, is that notice of termination needs to be in writing. And depending on how that notice is given, that can be working notice of termination. So generally speaking, severance, another word for severance is payment in lieu of notice of termination. What our courts say is that working notice is equivalent to payment in lieu of notice. So if a company were to give you written notice of termination and say, we will be closing in 12 months, this is 12 weeks notice of termination, and that it could be that that's all you're entitled to. You may also be entitled to more, depending on the factors and considerations of your employment. It could be as much as 24 months. So if that is the case, again, reach out to us at employmentlawyer.ca, and one of our lawyers will be able to help you out. Okay, so before I wrap up, MJ on YouTube asked a question about being a unionized employee. MJ, when you're a unionized employee, unfortunately, your rights are very different. You fall into the realm of labor law. So in that case, it's important that you reach out to whoever your union representative is, and they'll be able to help you out and discuss your rights with you. So that's my time for today. It's 1:30. I thank everyone for joining for today's iteration of the Employment Law Q&A. Again, my name's Teilen Celentano, and I'm an employment lawyer and associate at Samfiru, Tumarkin LLP in the Toronto office. I look forward to seeing you guys again, and please join us at our next Q&A. Thank you.